The next case to come before the court is State versus Burroughs. Good morning.
Good morning, Your Honors.
You will have 15 minutes and you can reserve up to 5.
I'd like to reserve 4.
Okay, sounds good.
May it please the court, my name is Michael Stefanik. I represent defendant Colin Richard Burroughs. Mr. Burroughs, a case where he's charged with trafficking offenses, placed under arrest, indicted, never waives time, never files a motion for discovery, tries like heck not to have any tolling events except files a motion to reduce his bond. From the time of his arrest until the day of his trial, he's incarcerated in excess of 270 days. He's incarcerated for 315 days, subject to the triple count provisions of the revised code. The state, upon us, or Mr. Burroughs, filing a motion to dismiss for speedy trial, stated that Mr. Burroughs was actually being held on more than one offense. He was being held on a post-release control violation. I don't believe that that's accurate. I had given the court supplemental authority from his 8th District Court of Appeals case stating that the 8th District trial court had no authority to place him under post-release control, that any attempt to place him under post-release control is void. I think that's notable language because the Ohio Supreme Court says that when it comes to void sentences. This court says that when it comes to void sentences, and the 8th District in Mr. Burroughs' case said that when it comes to void sentences. Not that Mr. Burroughs was placed on post-release control and it was later determined to be valid or invalid. It's that we don't even recognize that as being put on improper post-release control. We recognize that at best as an attempt to place on post-release control.
This supplemental authority, though, that wasn't something the trial court had in front of it.
It was not, because at the time that Mr. Burroughs was accused of having his parole holder on him, that was a situation where the trial court there had not made a decision. That litigation was going on regarding his post-release control being void at the same time as this case was proceeding through court.
Right. Well, only reason I'm mentioning that is I'm not sure we can consider that's almost like a fact-finding type thing as to what the 8th District determined it to be after the trial court already made a decision. But anyway, we'll decide. Yeah, yeah.
Sure.
I'm just saying, that's a little unusual.
I don't disagree with that. I get the point.
It's like you're putting new things into the record.
Right. But it's an issue of law. It's an authority, I suppose, and it's a recognition that Mr. Burroughs was making the argument to the trial court that his post-release control was void, therefore the holder placed against him was invalid. The state actually, in an attempt to argue counter to that, called Ms. Cheryl Casco at the motion to dismiss hearing, actually after the motion to dismiss hearing. And Ms. Casco was asked whether she had placed a holder on Mr. Burroughs. And upon cross-examination, she was asked whether Mr. Burroughs' post-release control was valid. And she did not know the answer to that. She said that's not her job, not her duty. When she's told to supervise someone, she supervises someone.
Well, so would it have mattered had she answered the question? Because that would have been a legal conclusion rather than a factual statement. She did go on to say that he was a probationer who was assigned to her.
Correct.
That she took the order to the Lorain County Jail, the holder,
Correct.
And filed it there.
Correct.
So, I'm just wondering whether or not the fact that she said, that's above my pay grade really makes much of a difference.
Well, I think that what it goes to is that the state didn't care whether Mr. Burroughs ought to have been on post-release control. She just said, hey, I don't know the answer to that. And she's called as a witness, for the purpose of saying there's a valid parole holder, and the state never bothered to figure that out. And I think that's an issue.
But wouldn't that be in that case? There's two different cases going on here. Really?
Post-release control is...
In the other case,
Right.
not this case.
It's the other case, but he's supervised in Lorain County for, based on an order. Anywhere in the state he's at, he's going to be, either on post-release control or not on post-release control.
So if we go along with your position, then each court would have to make a determination, almost have a trial within a trial, as to the validity of what was going on in post-release control, what the court said at the time the defendant was arraigned, what the court said at the time the defendant would plead. Is that reasonable?
Entirely. Because I think, first of all, post-release control and the issue of a holder or post-release control being void. I mean, and that's I can't think of, I guess, in terms of incarceration, any other sentence being void. It's not a situation where the court reverses it on appeal, saying, hey, there's insufficient evidence, so therefore maybe you should never be. Void just means it never should have existed.
But how would Judge Ewers know that when that's in judge somebody else's case? Judge Ewers doesn't have the authority to make a decision in somebody else's case. So how would he know that's going on in this collateral case over here?
I don't know that he would be required to make a decision.
Right.
But just, hey, Judge, we don't think that this order is valid.
And that was taken up in the other case.
It was also raised, though, in this case. Ms. Casto had no idea whether this holder was valid, and the state actually went to great pains to try to prove that it was. But I think it's very, nowadays, because the statutes have changed to say, hey, we'll give the state a mulligan, we'll give judges a mulligan, you just re-sentence the guy. It's only going to be people who have done their entire sentence and then are placed on post-release control, and it wasn't corrected in the interim. So we're talking about very, very few cases. And no, I don't think that it's going to be the court's duty in any case to say, well, hey, I understand you're on post-release control separately, let me just take it upon myself to look into it. But when you have an attorney that is looking into it, has looked into it, has filed appropriate motions, and is bringing this to the court's attention to say, this shouldn't count.
But what if it happened the opposite? Let's say this. Let's say that he was released because the court said it wasn't a valid post-release control, and then the court later said it was valid.
State can appeal it.
Well, that's my whole point. And then the guy goes back and is put back in jail, or has jeopardy attached. I mean, you see what I'm saying? Because what I'm saying is, what if you had won? And then we reversed and said, nope, judge was wrong. It was a valid holder.
Then I think he was held on a valid holder.
But he's already out. And he's put back in jail and refacing the charges. Because everybody's operating under the basis of this holder, and time is counted on the basis of this holder. And the state, assuming that they're acting in good faith, which I don't think anybody's making an allegation or not,
Sure.
but assuming they're acting in good faith, is relying on bringing him to trial based on a computation with a holder being placed.
I think if it happened the opposite way, the judge said it wasn't a valid holder and they dismissed it for speedy trial, I don't think jeopardy would attach. I think he would just, the Court of Appeals would say, this was a valid holder, so the 315 days should be down to 240. And then the indictment's reinstated, and Mr. Burroughs goes on to trial. And again, I think this is an increasingly uncommon situation. A couple of years ago, people would come to the office and say, hey, let's look at your post-release control, and very often we would see it. I haven't seen an error in post-release control on anybody that's currently serving a sentence. I think most of them have been corrected, so I guess if there's any kind of fear that, are we going to look at all these things? No, I think there are very few that probably need to be corrected. This was one that was, and was brought to the trial court's attention. I know that the state had cited some other cases from the 11th district, both stating that a parole holder, even if it's later determined to be invalid, will not will not permit someone to then take advantage of the triple count provision. I think it was Henderson and Vasquez were the two cases. But I think that in the Henderson case, the court at the very end said that he was not being held on the pending charges. And I'm sorry, that's the Henderson case. And then in the Vasquez case, Mr. Vasquez posted bond very early on in his case. So the Court of Appeals said, wait a second, if you're held on something totally different, we're not going to give you triple count provision for a parole holder. Whether it's valid or not, let's say it was valid in that case, it doesn't change because Mr. Vasquez had, and it's in the first page of the opinion, he had posted a bond on that case. So no, it's almost like if Mr. Burroughs had posted a bond in this case, I could not argue that he's entitled to triple count for this parole holder because if he posted bond on the case, he's not in custody on that case. So I don't think that those cases really mean a whole heck of a lot. There is a case, State versus Green. I had cited that in my case, in my brief. And what that stood for was that the state didn't prove a valid holder. And I know that the state's response was that, well, that was an evidentiary thing. Well, the point is, if there's not a valid holder, whether it's insufficiency of proof or it's just not valid, it shouldn't count. In that case, cites a Ohio Supreme Court case, State versus Brown, where it says that a valid holder will defeat triple count. What I'm saying is Mr. Burroughs did not have a valid holder because a court determined it was void. And that the attempt...
And the court was considering that, the decision, whether it was valid, did not have before that the court had determined it was void.
No, because that didn't come until after. But the argument was still made. That was the other issue that I had was
You're in your rebuttal time, but go ahead if you like.
I specifically asked Judge Ewers, Judge, can you give us some findings of fact and conclusions of law? Can you give us an understanding of why I lose? And he said, I talked to my colleagues, I don't think I have to. I'll talk to you.
Thank you.
Your Honors, may it please the Court, Mary Solanska on behalf of Appellee, the State of Ohio. In this case, I think that the case cited by the appellant, his case from Cuyahoga County, where at court held that his parole hold, or not his parole hold, that the post-release control, imposition of post-release control was improper because he wasn't properly advised, really puts this case squarely within State versus Henderson. In Henderson, which is a 5th District case, the court held that even if the post-release control sentence or hold is invalid, a defendant is not entitled to the triple count provisions under the speedy trial statutes. And the court held that even though it had subsequently found that the post-release control was invalid, the imposition of post-release control was invalid, they didn't matter to the pending charge. And in Vasquez, the 11th District Court said, they talked about the validity of the confinement, and they said, well, perhaps it's of great importance in the proceedings that are the cause for the confinement. It's not of any importance to a prosecution who's disrupted by that confinement. So what they're basically saying is, it's impossible for a trial court to evaluate the merits of the potential speedy trial violations where the merits are dependent on the outcome of other unrelated proceedings. And that's exactly the situation that we have here. This court hasn't addressed the issue, and the Supreme Court did not address the issue in State versus Brown. Contrary to the defendant citing Brown in support of his argument. In Brown, the Supreme Court did not address the validity of the post-release control. It was not considered by the court. The sole issue was whether the defendant's failure to request findings of fact and conclusions of law, and the trial court did not issue those, whether the Court of Appeals erred in reversing where the record contains sufficient evidence to support the trial court's decision to deny the motion to dismiss based on a hold. So what they're saying is the state in that case proved there's a hold, and the issue is did the Court of Appeals err because there were no findings of fact and the defendant had failed to request them. So that Brown doesn't really stand for the proposition that the validity of a parole hold has to be determined for purposes of a speedy trial in an unrelated case, and that's exactly what we have here. And that falls squarely within Henderson from the 11th District, Henderson is the 11th District, I apologize, I believe I said it earlier, and Vasquez. And I think that the court's analysis in those two cases is very persuasive here, and that this court should apply that analysis. And basically that's that the trial court is not in a position to have, as the court has noted, a mini trial within a trial about the post-release control. Because what you're essentially getting into is Judge Ewers is going to have to say, in Cuyahoga County, when they impose sentence based on that sentencing entry, it wasn't valid, and so I'm going to say that that's not here. And what if then, as Judge Carr, you pointed out, the 8th District Court of Appeals had looked at the case and said, no, for whatever reason, which doesn't really matter here, it's the post-release control is valid, and they overturned the trial court's decision. Then what you would have is the state has now had the case dismissed, and at some time, possibly well beyond when the state could appeal the issue, the 8th District Court of Appeals comes out and says, no, it's a valid hold. But Judge Ewers has looked at it and said, it wasn't valid. He was wrong. The state can't appeal the fact that he was wrong because our time has run. So you're putting Judge Ewers or any trial court in the position of having to consider the merits of an argument that's properly before a different court in an unrelated case. What the court has to do is look at, is there a hold? And as the defendant pointed out, and again, this puts this well within Vasquez, and I think it goes to Judge Carr's point that there's no allegation of that the state acted in bad faith in any way. As defense counsel pointed out, the defendant filed the motion to dismiss, and typically those are, boom, it's filed like the day before trial or at some time. And so the state files a response, and they come in and they put the parole officer on, who then testifies, I lodged a parole holder and served it at the Lorain County Jail. And they actually admit State's Exhibit A, which is the hold that she identifies and says, that's what I served on, at the jail, and placed that hold on the defendant so he wouldn't be released on this Cuyahoga County case that he's under my supervision. And the trial court then has to look at, did the state present sufficient evidence to show that there was a hold? And the fact that at some point later, the validity of that may come into question or is even raised in this particular case is really not relevant to the issue, because what the court has to look at is, there's a hold. The state's acting in good faith. They're relying on that. They can't be expected, until the defendant files a motion to dismiss, to look at whether that hold is valid. So under that scenario, you would put the state under a burden of saying every time a defendant, you have a separate hold on a defendant, the state and the court then have to go and look at that hold and determine whether it's valid and whether it should apply in their case, and then count their time accordingly. And what happens typically, and what happened in this case, is that issue doesn't come up until all this time has passed. The state has relied on the fact that there's a parole officer who says, I put a hold on him because he's on post-release control to me, or on supervision. And so, you're putting the state in the untenable position of having to take the position of Cuyahoga County Court of Common Pleas and the 8th District Court of Appeals and sort of predict whether that's a valid parole hold. And that's not what the statute is about. It's whether you're held solely on the pending charge. And I believe that the state is entitled to rely, and the statute permits the state to rely on the fact that there's been a hold placed on that defendant. And as the 11th District Court of Appeals noted in Henderson and in Vasquez, it's immaterial whether there's some problem with that hold. If it was placed, if it was served, if the state proved it at the hearing, then the state is entitled to rely on it, because the state is essentially acting in good faith. in that basis. And, you know, as you pointed out, Judge Carr, there's no allegation the state acted in bad faith. And I'm not saying that that's what defense counsel is arguing, because it came up when the motion to dismiss got filed. And that's the point that people start then looking at it, and you're sort of after the fact. And I don't believe that that is what's intended by I guess, the reference in Brown to a valid parole holder, although that's not what the court didn't decide that on that basis. But they did use the term valid parole holder. And I think in this case, the validity is there a hold, and did the state prove that there's a hold, not actual validity of the hold itself. In other words, that unrelated case, as they talked about in Henderson and Vasquez, where the state can't know what's going to happen, you know, or only may be able to guess at what's going to happen in that case. And, you know, we're sort of putting the cart before the horse, because we have to decide now what may happen at a later time. And I don't think that you can put the state in that position, and I don't think that's what the case law holds in these cases. And I think the trial court was correct in denying the motion to dismiss, because when you look at when the triple count provision is not applied, the defendant was clearly brought to trial. I believe the state's calculation was 228 days. And that includes even if you didn't give him the period of time for the bond motion, which was addressed in the first assignment of error. I don't really think that that's a main concern, but it was raised, and I just briefly wanted to touch on the fact that even if you took that period of time out of the hold, and I've argued this in my brief, so in other words, we'll give him the 3-for-1 for that period of time, you're still at just 228 days, well within the statutory speedy trial time limits. Thank you.
You have a little over 3 minutes.
A couple things. I mean, let's say that a parole officer had a guy who was never on parole. He just doesn't like the guy. He goes to jail and says, here, I'm putting a hold on. He's not on PRC. He's never committed a crime before in his life, but I know that he's in custody here. The state says that that's fine. That he doesn't sit 3-for-1, even though there is zero authority for that person to do that. I know it's kind of a ridiculous argument. I know that I hope that that's never happened before. But it just highlights the point that what does void mean? I think the state is trying to say, well, this was merely voidable. But void means that it's as if it never happened, and the people should be placed in the same position as if it never happened, which is the lack of an existence of a valid holder. And I think that that's what we have in this court. Further, as to concerns that, well, you know, we might be beyond the time for appeal if there's a different determination in, like, the 8th District. Well, if Judge Ewers had found in Mr. Burroughs' favor because of the post-use control, the state could appeal that, regardless of what the 8th District Court of Appeals would do. I think that principles of res judicata or collateral estoppel would prevent somebody from going to a different district and saying, hey, can you guys go ahead and give me a different decision than what the 9th District Court of Appeals gave me? I think that that's a fear that's not realistic, and I don't know if it ever happened or ever would happen. I don't think that that's anything I don't think that's really a legitimate concern. As to the motion to reduce bond, I think the state had said that there were almost a month that told for that. The motion was filed. The state requested a week to respond. The state made a response to the motion. It was very, I'd say, boilerplate response. Did the state need a week to respond? No. A hearing was held a couple of weeks after that because the court was closed for inclement weather on, I think, February 5th. Well, the court was open the 6th, the 7th. It was open the very next week. I actually put in the motion to dismiss that there were several other hearings that the court had continued for just 1 week. But Mr. Burroughs, who was in custody, he was continued for 2 weeks. So what necessitated that delay? I don't know. I don't think anything. And again, part of the issue is Judge Ewers never told us why he did the things that he did. Never made any decisions, which I think does impact or kind of hamper individuals in determining the validity of these things. But I suppose if this court believes that the Ohio Supreme Court in itself is wrong in terms of improper attempt at post-release control resulting in a void order, and that it's merely voidable, then I lose. But based on precedent, not only in this court, the Ohio Supreme Court, that this doesn't exist, this order, then I think Mr. Burroughs is well beyond his 270 days, his 315 days. He need not establish prejudice for a statutory violation of speedy trial. And that's it. Thank you.
Thank you. The court will take the matter under advisement and issue a written opinion which will be sent to both sides, as well as you can look on our website, the Supreme Court website for the Thank you very much.